Hello, Realtors, and welcome to episode 365 of your SCR Update. This is your go-to source for what's happening in the world of real estate and how it impacts you. As always, I'm your host, Nick Kremydas, CEO of the South Carolina Realtors, and today I'm honored to have a very special guest that has been a counselor and advisor to many realtors in South Carolina. David Anderson is a shareholder of Richardson Plowden here in Columbia. He maintains a civil litigation practice with an emphasis on defending construction, premises liability, real estate professionals, and other insurance-related matters. After graduating from the Citadel, David served in the United States Army in various command and staff positions until 1992, when he left active duty to pursue a career in law while continuing his military service with the South Carolina National Guard. David, thank you for your service. Throughout his military career, he received many awards and decorations, including the Bronze Star for action in Desert Shield, Desert Storm, and the Legion of Merit for service in the National Guard. He retired with the rank of Colonel in 2006. In 1996, he graduated from the University of South Carolina School of Law, go Gamecocks, and in 2004, he received a master's degree in strategic studies from the U.S. Army War College. David, welcome, and thank you again for your service to your state and your country. So before we start, I want to welcome you again to our update today. David, why don't you take a moment to introduce yourself and tell us a little bit about Richardson and Plowden.
Well, thanks, Nick, for having me here this morning. Richardson Plowden is a civil defense firm, and we have 3 offices. Our main office is in Columbia. We have an office in Charleston and Myrtle Beach. We have approximately 42 attorneys, and we serve our clients throughout the state in civil-related matters.
Awesome. It's great to be with you today. And that's really what we're going to focus on today, Realtors. It's that moment in your career that is likely to come about at some point. Whether you've been in the business for a year or 30 years, there's a chance that somewhere along the way that you're going to have to deal with the Real Estate Commission when someone has filed a complaint against an agent in your firm or against you yourself. And we're going to talk about today, number one, how kind of like do's and don'ts, what you should do, what you shouldn't do. And number one, don't panic. And having David's counsel here today will help us guide you through those steps to ensure that you respond properly, protect your rights in the hearing process, and make sure that your ethical, professional business practices always have the opportunity to shine through. So let's start, David, if we can, with that first kind of oh no moment, the moment that a realtor receives a letter from the Real Estate Commission. So when a realtor receives a letter from LLR, the Department of Licensing and Regulation, the umbrella agency that includes, of course, the Real Estate Commission, they'll receive this letter notifying them of a complaint. So before they even think about the details, what are some first 2 or 3 steps that the realtor should take? And just as importantly, what is the one thing that they should never do in that initial kind of panic of receiving that letter from LLR?
Well, Nick, I think the first thing is to take a deep breath. Those letters will come either via email. They used to all be mailed, but now they're via email. And the first thing I would say is to make sure that you talk with your broker in charge, because now the broker in charge is supposed to simultaneously get notification from the commission of a complaint. The things that I would encourage you not to do is not to pick up the phone to call the complainant. You may or may not know who that is. Whatever transaction took place that they're questioning you about, I would not call that opposing or the broker or the agent on the other side. Don't make any of those calls. Normally now the complaint letter indicates that you've got 14 days to respond. Previously it had always been 10 days, but you need to start that clock as far as when you receive that notice. The second thing is, I would encourage you not to send that investigator or the person that's complaining, don't send them any information, because what that letter is asking you to do normally is to respond to the complaint and to produce documentation in many cases. And we've got the items that you're supposed to keep for 5 years, that documentation, but the first thing I would encourage people to do is to start writing down a chronological log of that particular transaction. When you first got that client or had made that transaction, who were the first individuals that you were speaking with. And the second thing is you need to gather all of your text messages and email messages, and that can be a exercise in labor, because depending upon your cell phone or how you text or how you communicate with the other side, you need to gather all of that information to get it, I would suggest, to counsel. I think you make a mistake by representing yourself in these investigations. You need to have somebody who's been there before, who has appeared before the board, represented individuals, and knows the process.
Because that's an impulse reaction, right? When a realtor receives this letter, their initial reaction is, hey, I want to clear things up. Let me send you all of this information. And that may end up causing a bigger problem than the original one, right?
Well, exactly. That investigator, this is not the first time that he's seen this complaint. The complaints now are done through the internet, and individual will fill the complaint out and send it to the commission. The commission then takes that complaint, they'll redact personal information off of it and send that along with the complaint letter to you. So that commissioner, or that investigator, has already received the complaint. They've already reviewed it to make sure that it makes sense, or that it is a valid complaint. If there's anything that looks like a real estate law has been violated, a statute has been violated, or anything that may harm the public, they're immediately gathering information and speaking to the complainant. And so they have a wealth of information already. You may think that, well, the investigator only has that complaint. No, by the time you get the complaint, the investigator's already probably interviewed a number of people, made phone calls. He may have been to the opposing or the complainant's home or business to take information. So he has all of this. And what he's wanting you to do is to provide your side of the story. And so once he gets that and gathers that, then he assembles all of that information to present it to the Internal Review Committee. And the Internal Review Committee will determine whether there's a violation or not, or whether they believe that there's a violation. And once that determination is made, then the disciplinary council gets involved, and there's a number of exchanges back and forth as to whether it can be worked out with a memorandum of agreement where somebody can admit that they violated a statute. They may have to pay a fine and take additional continuing education, and it goes, that complaint is filed then with the LLR's commission publicly. So what you hope to do, or what you hope that the ultimate goal, of course, is that the complaint gets dismissed. You get a letter of caution. It's not published, or it's just found unfounded. And that happens many times. But what you need to do, or your goal is to respond to that investigator, and within that time frame. And it may be, well, I want to get counsel, and I would ask for additional time. Normally when I get a complaint from a realtor is at the end of that period. And I immediately ask for a slight extension so that I can meet with my client and gather all that documentation. Once I gather the documentation, I normally bait label it. It's nothing more than labeling each piece of paper that we're printing out numbered wise. And so our narrative response to the complaint is going to refer to that documentation.
Yeah.
And our goal is to make it easy for the investigator to see our side of the story as to what actually happened.
I think a couple of takeaways that I have from what you just shared, David, that are very important to kind of restate or emphasize. Number one, I think realtors should probably treat every transaction as there could be a problem down the road, meaning document your conversations, document your text messages, your emails, certainly make sure your paperwork is in order and timely and proper signatures, all those things that you keep your files in order. And this chronological timeline is incredibly important. Number one, I know from a just pure psychological standpoint, it takes some of the emotion, some of the stress out of the equation when you can see on paper that you've done X, Y, and Z, you've communicated A, B, and C, and that allows you to kind of take some of the emotion out. I've sat in as board counsel on a lot of ethics hearings over the years, and with the invention of text messaging, that's been a blessing and a curse, and some of the worst evidence I've ever seen has been the result of text messages back and forth. So make sure that realtors, you document these things in your files. I think the second takeaway for me was having counsel that can help you take the emotion out of this. Like I said, I've sat in a lot of our ethics hearings, and there is a difference when a realtor is trying to make their own case versus having counsel there to make the case for them. You are inevitably going to be emotionally involved in these cases. Someone has questioned your business ethics, someone has questioned your business practices, and I think you have every right to feel like that's a personal attack. You know, I know a lot of people feel that way, and their first reaction is to, again, vindicate. You know, to explain, to ensure that they understand that you do not do these things you're being accused of. You want to clear your name, and having counsel can help guide you through those steps, taking the emotion out, and making sure that the investigator or the hearing panel or the commissioners themselves get that clear picture, and your counsel, your attorney, can help you do that. So, David, based on the cases that you're defending here in the last year or so, could you or would you identify, are there top two or three issues that kind of seem to be repeating that are getting professional realtors in trouble with the commission?
Well, here recently it's been because the interest rates are down, or correction, interest rates are up. Because they're up, sales are down, and because of that, there's been an increase of agents communicating with other represented parties, or trying to get another party who's already represented or a client of someone else's. And so I've seen a good bit of that here recently. There's a number of issues with property managers with not doing what they should do as far as appropriate record keeping and record keeping with funds. We've also had advertising, and I think the younger generation are more thinking outside the box with various ads or Facebook postings, and inevitably the Facebook marketplace, unless you're doing everything appropriately and identifying yourself, and you've got a listing agreement that's already signed, that may not be the way that you're wanting to promote your business. So we've seen a lot of that and kind of a crossover to people making statements in what are termed real estate investment groups on Facebook.
Yep.
And that is a recipe for somebody to point the finger at you, is to say that, you know, you're marketing inappropriately.
Well, we've definitely seen those trends reflected in the guidance letters that the Commission has been publishing. You know, in my career, I've never seen the Commission so proactive in offering advice and whatnot through these guidance letters. And advertising certainly has been a hot topic and addressed in those guidance letters. Realtors, if you're not bookmarking that front page of the Real Estate Commission's website, please make sure you check that on a regular basis. This year they've been posting something just about, I won't say every week, but it's been they've really stepped up their outreach in the community, trying to address these issues so they don't result in complaints and disciplinary actions.
Let me remark on that. This association does an excellent job of putting information out, but the LLR website is an excellent source, again, for that. And it surprises me the number of realtors that come to me, and I have to show them how to navigate that site and to look at complaints, to look at the alerts that are provided. And so if you're a broker in charge and trying to make sure that your agents pull up that site and spend some time on it, look through it, because it is very helpful. And they're doing a great job of, with reduced resources, of trying to get information out.
One thought I just had, David, you're absolutely right. I know our legal team routinely works with the Commission staff and on these guidance letters. One thing that I would ask realtors, because a lot of you know your commissioner that serves your district, that represents your district. The commissioners have been doing a great job of being very visible in the industry and in the community, speaking to local groups and being out in the field, so to speak. If you are the subject of a complaint, I would ask that you do not call your commissioner first. Your commissioner ultimately will be serving in a hearing capacity, possibly, if depending on the progression of that complaint. And if he or she has had communication with you early in that process, they will likely have to recuse themselves from any final decision making. So you don't want to do that. And they're going to tell you, don't call me if you get a complaint filed. But I think it's important to understand and kind of demystify this process. You know, when an ethics complaint is filed under the Realtor Code of Ethics, our hearing panels can issue a fine, disciplinary, education requirements. But there's one thing that the Realtor Association cannot do, and that's take your license away. They cannot suspend your real estate license. That can only be done by the Real Estate Commission. And many members, when they do receive a complaint, they think that this is going to result in they're losing their license, losing their livelihood. But David, can you talk about some of the potential outcomes to take some of this fear out? Certainly, if you're a repeat offender and you're constantly, breaking the law, the Commission isn't going to have a whole lot of time for that. But there's a lot of accidental violations, right? Whether it's misinformation, miseducation, or that's not a word, but needing better training in the field. What are some of the possible outcomes when a complaint is filed against a realtor? Well,
of course, the one that we hope happens is we get a letter back from the Commission saying that the investigation's been dropped. It's unfounded. But
now, let me just interject. I'm sorry to interrupt, but based on the information that we get from the Real Estate Commission staff, the vast majority of complaints are dismissed because they either fall outside the scope of license law or maybe frivolous. And of the complaints that move forward, the vast majority are against property managers, which you highlighted earlier. So even though there's a large volume of filed complaints, I think the Commission actually, I think last year, Austin's not here for me to ask, but I think there were about 300 or so complaints that kind of went past the IRC last year.
Well, in fiscal year 25, there were 621 complaints. And of those complaints, 227 had an investigation commenced. And of that 227, the average length of that investigation was 198 days. However, that's kind of misleading to a certain extent because cases over 150 days presently is 185 of those cases. And that's just pulled off of the website with LLR. So majority of the cases, it takes time for the investigators to complete their work, present it to the IRC, and then the IRC presents it to the Commission, and the Commission's got to sign off on it. So
the IRC is the Independent Review Committee, and it's appointed by the Real Estate Commission, and they serve kind of like a grand jury. They kind of review the evidence, and
that's correct. It's normally the director, the investigator. There's a licensee in there. They don't tell you who is on the IRC. Sort of like a grand jury. They don't tell you who's there or who is there now, but they have an opportunity to look at both sides of the complaint and see whether there is grounds for a violation. And once that's done, I've had clients that made a mistake. We clearly want to say in our response, if we've made a mistake, we say that. We also would try to give any type of extenuating circumstances. I've had clients that have been under extreme mental issues because of deaths in the family or severe things happening in their life that caused them to overlook or do something that was outside the bounds. Those needs to be explained. If you had a serious surgery, or you've had medication or things of that nature that may have impaired your thought process during that one particular instance, that needs to be explained. A good thing about having...
So those extenuating circumstances, showing remorse if you've actually done something wrong, those all factor into the final decision the Commission may make, right?
That's correct. Now, you're going to have an opportunity to evaluate that what the IRC is suggesting takes place through communications back and forth. Ultimately, you can present your case before the Commission, but that's the last thing you want to do if you can work something out before that time. And so you have to weigh your options. If you've been cited before, then you're starting at a bad position because they know that, and they know that you've been cited before, and they take the position that you haven't learned from your past mistakes, and so they're going to be scrutinize that further. We've had cases where the IRC suggested a particular course of action, and the Commission overrode that, and they're making the case go before them so that they can ask questions. You could agree with the factual elements of the complaint, but then not agree with what the IRC is suggesting or the disciplinary council is suggesting is your punishment. In other words, you could say, well, that's too much. I want to present my case and present myself before the Commission and have them make that final determination. And of course, the Commission again, go to the website and look at those commissioners. But majority of them are active realtors throughout the state. And so you're going to be presenting your case before them. And it's important that you are speaking with candor. You show your sincere desire to continue as a realtor, and explain your case. One thing that having counsel, that perhaps an individual, if they're trying to represent themselves or go there with their broker, if you've got a medical issue that should be discussed privately, you can ask for the proceedings to be a closed proceeding. And so they would not broadcast that portion of the proceeding, and they would empty out the room. So all the investigators, everyone that doesn't have specific interest in this particular case, they all have to leave the room while you present yourself. People don't know that unless you've appeared before them many times.
Well, I think you've laid out a very strong case, David, for the importance of having counsel with you during this process, whether it's at the initial stages of receiving the complaint, all the way through, of course, to if you have to appear before the commission or negotiating a settlement, so to speak, with the IRC. Having counsel there can prevent you from missteps that could impact your business down the road. I think that value proposition, going it alone is a dangerous prospect when your license is potentially on the line. It reminds me when I was a young law student, just had graduated from law school and doing those courtroom appointed shadows that you were supposed to do, and I don't even know what they're called anymore. But I remember sitting in magistrate's court, traffic court basically, and watching alleged speeders appear before the judge, arguing that, hey, everybody else was speeding. He was the cop was just picking on me, and that's probably not a great argument to make. And certainly it was a loser every time I saw it happen. Going there and being prepared to fight or argue on your own, I think, is a recipe for disaster.
Let me just say a couple things that it amazes me sometimes when people come into my office, but all realtors, or at least the majority of realtors, have E&O coverage, errors and omissions coverage. And a determination will be made whether or not, if it's a civil suit, and I defend a number of civil suits with realtors involved, and it's normally the realtor, in the vast majority, have not violated any statute, but yet they're in a civil action that's being defended by errors and omissions policy. The vast majority of those errors and omissions policies, though, also have a provision in the policy that they will provide you counsel for a license complaint with the state licensing entity. And CNA, for instance, will provide up to $10,000 in defense costs to defend a realtor. And that doesn't come off of your deductible. Arch Insurance has the same program. And so I would encourage you to look at your insurance policies. The first thing when somebody comes to me, I ask whether they've got insurance for it. Now, if they're a large brokerage and they have a number of hits, they may want to curtail making claims to their insurance policy. But most policies will provide coverage for an LLR related complaint for that agent. And the theory behind that is they want that agent to continue to be an agent and pay those premiums. And so the same thing is with a subpoena. You get, many times a realtor will get a subpoena for the transaction file, and it may be as simple as the parties are divorcing and they want to see what's in the file. But there's some times where it's a property dispute and they are looking and fishing to bring in other parties. And so most insurers will appoint counsel for that. It's not off of your deductible. It doesn't come, it's not a hit on your policy. it's a free benefit for that, because that defense counsel can look at what the underlying suits are to see whether there's exposure for that realtor, and hopefully respond to the subpoena in such a manner and talk to those attorneys to reduce the exposure. So the theory, the insurers, or the theory behind that is that they want a licensed attorney to look over the situation and respond to that subpoena, and that's not off of your deductible, and it doesn't count against your policy. So I've just urge people to take a look at your E&O policy and read that in your course of business.
David, that's another great takeaway from our talk today. So realtors, I think we've given you a kind of a broad picture of what happens when a complaint is filed, how you should react, what steps you can do to take to protect yourself, protect your business, and take the fear out of this, right? As I said at the very beginning, if you're in business long enough, you're going to get hit with some type of complaint, more than likely in your career. It's not something to be afraid of. If you know the process, you'll know how to deal with it. And we've got great resources here at SCR, Richardson Plowden and their team, and LLR's staff and their website and their resources. All of those are tools that can help take the unknown quantity out of the ethics and complaint process, so that you can deal with these issues with confidence. Because unfortunately, as we've been familiar over the last couple of years with class action lawsuits and all the other litigation happening in the industry, it is just part of our business. It is part of your business, and being prepared is the best plan going forward. So, David, let me thank you again for being with us. It's been a real honor and pleasure having you today.
Thank you, Nick.
Thank you again for your service to our country. What an incredible career, and just thrilled that you were able to share some wisdom with us today. Realtors, I hope that all of you are enjoying this cooler, almost fall-like weather. Perfect timing for some Gamecock football this weekend. I hope all of you are safe and stay strong, and we'll catch up again with you real soon. Take care, everyone.